Hello, everyone. My name is Núria González, and I am an assistant professor of constitutional law at the University of Barcelona. First of all, I would like to thank Professor Martinico and Diritto Comparati for giving me the opportunity to share with you some comments about my first book that has just been published by Oxford University Press. Here you have the book. The book is called Secession and European Union Law, the Differential Attitude. The origin of this work lies in my doctoral thesis, which I read in Oxford in 2019. The book is about secession and European Union law. It is true that secession within well-established democracies is something exceptional, rare. But in the last decade, we have seen the consolidation of pro-independence movements in Catalonia and in Scotland. And in the near future, we might see their re-emergence or the rise of other pro-independence movements in other European regions. The response of the EU to secessionist attempts within member states might be based on political considerations, that's true. But since the EU is a community of law, it also has to justify its position with normative arguments. And this is precisely the aim of this book. This book tries to offer a normative support. The intention is to offer legal reflection that goes beyond a case-specific approach. The book is not concerned with the moral legitimacy or the political convenience of pro-independence movements. I just assume as a fact that in some European regions, there are strong independence movements that challenge the territorial status quo. The main question of the book is the following. How should EU law respond or react to secessionist attempts within member states? Should the EU approach towards secession be a generous one, restrictive, or a neutral or differential? As you'll see, my argument is that the EU should have a differential or a neutral understanding, and therefore it should be sensitive to the constitutional legal order of each member state when it comes to secession. So the central claim of the book, based on Article 4, Paragraph 2 of the Treaty on the European Union, is that the EU duty to respect national identity generates obligations in the context of secession, provided, of course, that the values established in Article 2 are respected by the member state affected. So I believe, basically, that the EU should not have an autonomous position, but a differential one. Needless to say, I'm fully aware of the risks of Article 4, Paragraph 2, and the book addresses them in depth. And before I come to that, let me also mention some other aspects that are also included in the first part of the book. So first, the book addresses the EU legal obligations, if any at all, that derive from international law when it comes to self-determination, a concept that is closely linked to secession, as it is well explained in one of the chapters of the book. In this sense, it is particularly relevant to establish also the binding character of international law vis-a-vis EU law. Another important aspect, and there is a whole chapter on it, is the analysis of constitutional provisions of democratic societies regarding secession. And this is important because, as I said, the central claim of the book is that the EU duty to respect national identity generates an obligation in the context of secession to respect the constitutional legal orders of the member states. And when analyzing these constitutional legal orders to the member state when dealing with secession, we see that there are some common trends. And these common trends enable us to talk about lawful and unlawful secessions according to constitutional law. In this sense, I have to analyze certain European constitutional legal orders that have been dealing with secession: Spain, Italy, Germany, Belgium, also the UK. And I also explore other classic and new paradigms of secession in democratic societies, the US approach and, of course, the Canadian paradigm. When it comes specifically to EU law, it is clear that there is no provision regarding secession within EU member states. There has been never a proper secession within, or a successful one at least, within a member state either. But there are some precedents of territorial changes within member states, and there have been also secession crises in neighboring countries. And all these cases provide us with some guidance. All these cases are analyzed in the book: the independence of Algeria, the withdrawal of Greenland, the reunification of Germany. I also address the response of the EU to the cases of national fragmentation in the post-communist world, although they cannot be considered properly secessionist challenges. The book also focuses on the official statements and the EU reactions to the Scottish referendum in 2014 and to the 2017 Catalan crisis. And then we arrive to the main debate, which is the debate among scholars in this particular field, secession and EU law. There are those who consider that any secessionist movement is against the ethos of the European integration, and therefore the EU should be very restrictive. There are others who, on the contrary, believe that welcoming new states emerging out of a democratic secessionist process is a duty of the EU, because mainly, or because of Article 2, precisely, the values of democracy established in Article 2. And there are also those who make a distinction between unlawful and lawful secessions. I align myself with this latter group, but unlike some authors, I believe that the key provision to justify the differential or the neutral EU approach is to be found in Article 4, paragraph 2, as I said, the principle of respect for fundamental constitutional structures. Drawing on such provisions, and also particularly the case law of the Court of Justice, which is an example of constitutional tolerance, I argue that the EU should respect domestic constitutional orders. In the book, I try to explain the origins of this Article 4, the pluralist nature of the clause, the content of the provision, the risks, and also the red lines. And very briefly, let me summarize. We know that member states and the EU both claim sovereignty, but at the same time, they try to avoid direct conflict through making concessions to each other. This Article 4 is a way to arm national and EU law with weapons that help ensure mutual respect and restraint, using here the words of Professor Nick Barber. This article is a form of public recognition of the multinational composition of the EU and a way of showing respect for the national identities of the member states. So Article 4 is a core provision to understand the federal nature of the European Union. It protects diversities in the EU legal order, and it does not stand mainly to protect those values that are common to the member states, but to respect those values and principles which differentiate member states from one another. But of course, and we have seen that, there are risks attached to Article 4, paragraph 2, because it could be used, and as I said, we have seen that, it could be used as a trapdoor to escape EU law obligations. But there is another article in the same treaty that could help us to prevent that from happening. And that provision is Article 2, which has been recently developed by the Court of Justice into a judicially applicable provision. It has been fleshed out, as Professor Daniel Sarmiento has explained. And also here, quoting Professor Martinico, Article 4 should not be read in splendid isolation, but in context. And an important part of this context is precisely Article 2. So my point is that member states will enjoy the benefits of constitutional tolerance as long as they do not violate the values established in Article 2. And in this sense, Article 2 is the playing field of Article 4, Paragraph 2. However, I also want to be clear. Recourse to Article 2 in the hands of the Court of Justice should not be used to grab power or put into question the Union's federal equilibrium. It must be interpreted in a restrictive manner. This doesn't mean that the court cannot or will not resort to Article 2 when having to assess the claim of a national court regarding the constitutional identity of a member state. But the court has to do that with certain self-restraint. At the end, the book also explores the legal situation that emerges when a new state has been created and has been recognized by the EU and by EU member states. The book addresses the debate about state continuity and state succession. And it is argued that the rump state will continue with the EU membership, while the new state will have to ask for EU membership through Article 49 instead of Article 48, as some authors have sustained in the past. But in any event, the discussion about the different routes is relevant only to a limited extent, since regardless of the legal path that is chosen at the end, both require a high degree of political consensus. I also addressed the debate about EU citizenship, nationality, and secession. The book considers how far nationality law, which is governed mainly by internal law, is constrained by international, but above all by EU law. And I argue that member states still hold an important degree of autonomy when it comes to defining nationality. And therefore, the impact of EU citizenship in the debate about secession is very limited. Finally, the book explores the hypothetical scenarios of an independent Scotland joining the EU, and also the possibility of Irish reunification and the position of the EU towards both situations. And this is mainly the summary I wanted to share with you. I'm afraid that I'm running out of time. Thank you very much for your attention.